Welcome to the July 26, 2022 Zoning Boards of Appeal meeting of the town of Raymond. The Zoning Boards of Appeal will come to order. The board does have a quorum. I am now going to do a roll call. I'll go ahead and start with you first, Tom.
Tom Hennessy.
Fred Miller.
Pete Lockwood.
Greg Dean.
David Murch. This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you're unable to see or hear. The board works from a published agenda and will be considering tonight's items in the following order. Number one, call to order. Number two, election of a chair and vice chair for fiscal year 2023. Approval of minutes from the June 28, 2022 meeting. Number four, old business, public hearings as follows. First, administrative appeal, read notice of violation issued 12/16/2021 for property location 18 Fernwood Road, behalf of management controls. Second item, administrative appeal, read notice of violation issued 1/4/2022 Q Team Inc., 18 Fernwood Road. Third item, administrative appeal, read notice of violation issued 1/28/2022, applicant management control, 28 Whitetail Lane. Administrative appeal, read notice of violation issued 12/28/2021, applicant Durant Excavating, location 18 Fernwood Road. Administrative appeal, read notice of violation issued 1/28/2022, applicant Durant Excavating, location 28 Whitetail Lane. Administrative appeal, read notice of violation issued 3/10/2022, applicant Big Lake Marine, Robert Durant, member and manager, location 18 Fernwood Road. And finally, administrative appeal, read notice of violation issued 3/10/2022, applicants Big Lake Marine, Robert Durant, member and manager, location 28 Whitetail Lane. Fifth item is new business, of which we have none. Sixth item, code enforcement office communications, and then finally adjournments. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court, as otherwise provided by law, within 45 days of this board's decision. Also, to be certain that you preserve your individual rights to file any such appeal, you must be certain that that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to stand at the microphone, state their name and address and affiliation with the application. For, opposed, or neutral. All persons speaking shall address all remarks or questions to the chair. This meeting is not over until the board has formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside the meeting room. So next up on our agenda is our annual election of a chair and a vice chair for the current fiscal year. I will entertain any suggestions for nominations to chair.
I'd like to nominate David Murch.
I'd like to second that.
I will say that I would accept the nomination, but I'm not having to feel like I have to continue as chair. I certainly am willing to share the wealth. Greg, Tom, Fred, Pete, if you have interest in being chair, certainly put that out there. Doesn't sound as so. Do we have a motion?
So moved.
Effect. Do I have a second?
Second.
Okay, any further discussion? All in favor of electing David Murch as chair for the upcoming fiscal year, current fiscal year 2023? All those in favor, has to be a roll call vote. David Murch, I will say yes.
Greg Dean,
Tom
yes.
Hennessy, Tom Hennessy, yes.
Fred Miller, yes.
Lockwood, yes.
Okay, so now we move on to an election of a vice chair. Do I have any suggestions for that? Personally, I think Greg has
I'll
done,
nominate Greg Dean.
I'm going to say I believe Greg has done an excellent job, certainly helping us with modifying the bylaws. But I also say if anybody else out there would like this position, certainly feel free to put that out to them. Okay, so officially, do I have someone who would nominate Greg, motion for Greg to be vice chair for this fiscal year of 2023 of the ZBA? Actually, I should ask Greg, are you interested in continuing this?
Happy to help.
Okay. Don't want to assume, sorry about that. Should have
No,
given you
fine.
a chance to talk. All right, do I have an official motion for Greg as vice chair for the upcoming fiscal year 2023?
I nominate Greg.
I'll go ahead and second that. We'll do a roll call vote. All those in favor of electing Greg as vice chair for this fiscal year 2023? David Murch in favor, yes.
Fred Miller, yes.
Tom Hennessy, yes.
Greg Dean,
Lockwood, yes.
Okay, very good. So unanimous. So Greg and I will continue on in our roles. Next up is approval of minutes for the June 28th, 2022 meeting. I did find one issue with it. It was on, let's see. Sandy, it's when we were going through Fred Hollister's application for 67 Wild Acres Road. I think it's on page 3. Item, as we were going through, we were reviewing the ordinances about the 4 hardship criteria, and it says item 3, last sentence says the board unanimously agreed that this criterion was not met. It's my understanding that it was met. Is everybody, as my fellow board members, in agreement that that should be changed to was met?
I agree.
Yep,
Okay.
I believe that's correct.
I will change that, guys.
Okay. So all those in favor, I need a motion actually to approve the minutes with the modification to item 3 on page 3.
I'll move to approve as amended or as in proposed amendment.
So I have a second on that.
I'll
Second,
Any further discussion? All those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Lockwood, yes.
Fred, did you, I might have missed it. Did you?
Yeah,
Okay, very good. So moving on, old business public hearings as follows. It was discussed in advance that there may be some benefit after getting through our first administrative appeal, which was tabled to sort of go through these tabled appeals in order which matches their locations. So group all the 18 Fernwood roads together and then group the 28 Whitetail Lanes together. So we're gonna take them out of order, essentially just shifting up the 18 Fernwoods and moving down the 28 Whitetail Lanes. We as a board do have the discretion to do that. I believe that the attorneys and the representatives are in favor of this, but I ask the board, since this is our decision as a board, does anyone take issue with doing these out of order and instead grouping as by location? Any board members, are you okay with that?
I'm okay with it.
No objection.
Okay.
Sounds good.
So I don't know if we officially need to vote on that, but what we'll do is we have our first administrative appeal tabled item, re-notice of violation issued 12/16/2021. Applicant the Rochin Esquire on behalf of Management Controls LLC, location 18 Fernwood Road. map lot 001-022, zone LRR2, excuse me, description of administrative appeal from notice of violation. Do I have a motion to take this off of the table?
So moved.
Seconds?
Seconded.
Any further discussion before we vote? All those in favor of taking this administrative appeal off of the table? David Murch, yes.
Fred Miller, yes.
Greg Dean, yes.
Lee
Tom
Lockwood, yes.
Hennessy, yes.
Okay, so we have this off of the table. Before I transition over to you, Attorney Wagner, I do want to just say that we do have a new member of our zoning board of appeals. His name is Pete Lockwood. Pete, can you just let everyone know what you've done to prepare for this evening?
Sure. I did review the videotape for the meeting that took place on March 29th. That took up a good part of the day. And then I reviewed all the files that were sent to us in a zip file and have read all of them.
Okay, very good. So Attorney Wagner, I want to transition this over to you before we move much further along. This is the administrative appeal that we met on back in March. We did review, and I believe you're going to write up a decision for us. So if you can just sort of fill us in on where we're at with things and what our next steps are here for moving forward.
Sure. Thank you, Chairman Murch. Let me just first clarify in terms of the quorum that's voting on this. I appreciate that. Sorry, Pete, your last name?
Lockwood?
Lockwood. Member Lockwood, I appreciate you stating for the record that you've reviewed everything. And so I think, in my opinion, and certainly parties could raise an issue and we could address it if anybody has any objections to it. But in my opinion, you're good to vote on any of these matters, but my recommendation would be that you just participate and vote on all of the appeals except for this one here, because we already are almost done with this process. So you can certainly participate in the discussion, but I would ask that you abstain from voting on this first appeal.
Okay, will do.
Okay. So where we are at procedurally is last meeting, the board went through and made findings of fact and conclusions of law and took votes on the individual issues that were on appeal and reached a tentative decision, and then instructed me to write up that tentative decision in a written decision. So the next steps for the board are to go through or confirm that you've gone through and discuss any changes to the draft decision that I circulated in advance of the April meeting, and confirm that that draft decision is consistent with the findings and conclusions you made, and then we'll need a vote to make a final decision on the appeal, and then that will be the final decision, and I can make any of the last minute changes that we've discussed to the draft decision, and then pass that along to Sandy and have you all come into the office to sign that. But the decision will be made tonight, and that's the decision for purposes of appeal. So unless there are any questions from the board, I would suggest that if everybody has it in front of you, or I can certainly screen share the draft decision, and I'd entertain any questions from the board on that. If you think something doesn't reflect the decision, or next step would be well, I can go over the changes that I've made, and then there would be a motion to pass that as the final decision.
Yeah, if you'd be willing to screen share and we can accommodate that, that would be excellent.
So are you all seeing a Word document entitled Draft Decision, Administrative Appeal, and Management Controls?
Yes.
Yeah.
Okay. So this is the decision circulated in November, or not in November, I'm sorry, April. You'll see I've revised the date of decision to read today. And the written decision should be whenever you all come in to sign this. We'll date the last person to sign. And I've modified the paragraph here beginning with April 26, 2022 to reflect that in April, the board unanimously voted to table further deliberation on this, and that it was subsequently continued during the May and June meetings of the board, and resumed consideration or deliberations on July 26th. And this paragraph here, I'll finish at the end of today's deliberations. I made a couple nits, small edits and non-substantive edits in the first paragraph here. I've added a second reference to the second link to another portion of the website. I discovered as I was going through it this weekend that it looks like we have sort of the case history materials are in one link, and some of the other materials are on another link under the current agenda. So I've just linked to both of these, and I think perhaps Sandy and I can coordinate afterwards and see if we can just get it all consolidated into one location that's stable, and we can provide a link to that. Skip the non-substantive edits there. And go down to item number 7 concerning violation 12 on a request from Attorney Rachin, was asked to strike the reference to 16H2 as that was not part of violation 12, and I think that was just a drafting error on my part, and Attorney Wyckoff agreed to that change so long as the reference to 16H2 remained down in this portion of the decision. I agree with that, and I've made that change, but if the board has any questions about that, or if it wants to open that up to discussion from the other attorneys, certainly can do so. Okay, hearing none. That is the only other substantive change. So does the board have any questions or proposed revisions to this draft decision?
I did not have any, but fellow board members, do you have any?
I don't have any.
None from me.
None from me.
Okay. So I would suggest a motion to grant the decision as written in the draft decision before you. And just to clarify, I know we have some findings here where there was a mixed result on the board. So voting for this decision doesn't change your vote on that particular finding. It just confirms that this is the final decision of the board.
So moved.
I'll go ahead and second that. Any further discussion by the board or for our attorney?
I'm all set.
Okay, again, remember, gentlemen, this is a roll call vote. You'll be abstaining. All those in favor of accepting this decision, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Okay.
I guess I should say all those and all those abstaining. I guess that gets you officially in there, Pete.
Okay, and I think we have a 4-0-1 vote on this, and I will finish this decision up and get that to Sandy tomorrow.
Okay,
She can make
thank you.
arrangements with you all to come in and sign it.
That sounds good.
Okay, and then Sandy, I just wanted to flag for you, and I can provide you instructions. We just have to make sure the written decision is sent out to all the parties as well as the DEP.
Oh, absolutely.
Okay, so next up, we have additional items of notice of violations on the table. Do I have a motion to take the remaining items of notice of violations, all of them off of the table?
So moved.
Do I have a second?
I'll
Second.
second that.
Okay, any discussion on this before we make that decision? Okay, all those in favor of taking the remaining items off of the table? David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Lockwood, yes.
Okay, unanimous. So these items are off of the table. Next up, continuing along for 18 Fernwood Road is administrative appeal, re-notice of violation issued 1/4/2022. Applicant Leah B. Ratchin Esquire on behalf of Q Team Inc. Leah, I do see that you are here. If you would like to go ahead and move forward with this
So,
presentation.
Mr. Chair, sorry,
Oh, yes,
do
yes.
you mind if I interject first?
No, please do not. I mean, please
Okay.
go ahead.
No problem. I just want to rewind a bit, especially since we have a new board member, just to go
Sure.
over the overall procedure. So this is a de novo hearing. So that means essentially this is the board is looking at it afresh. New evidence is allowed. And doesn't owe any deference to the code enforcement officer. So it's just taking the issues as they are raised by the appellant and applying the facts to the standards that apply to make factual findings and conclusions. And keep in mind that the appellant, the person bringing the appeal, has the burden here. Before we get into the presentations of the parties, I think the board should go over the first establish a quorum again. So I know we did that previously, but I think we should do it for each appeal. So Chairman, can I turn that over to you?
Sure. So you're looking for us to do another roll call?
Yeah.
Okay, very good. So David Murch,
Greg Dean,
Tom Hennessy,
Fred Miller,
B. Lockwood,
and that is a quorum.
Okay. And then I would suggest that you as chair ask if any members of the board have any conflicts of interest or bias that they wish to disclose, and then give an opportunity if any of the parties here want to raise any objections to that effect.
Good point. So gentlemen, any of that, any conflicts of interest or issues that we should be aware of before moving forward?
Dave, may I speak?
Of course.
When we started this in the first meeting, I had mentioned that I had done some work in this house many years ago for a previous owner. So I just want to make sure that's everybody remembers that I have done some work inside the house and flooring, because I am a flooring business. And I believe there was no objection when I was last time.
On behalf of the town, Eric Wyckoff here on behalf of the town, I can just reiterate, no objection.
On behalf of Q Team, same here, no objection.
Okay. So, and I will say, does anybody on the board have any concerns for Fred with this? I do not. I just want to make sure the board feels good with this as well. Not hearing anything, so I believe our board's good as well. So,
Okay. So that sounds like there's no further potential conflicts or any objections on that.
I would
Okay.
agree.
So the next step is to determine if the application was timely, or if the notice of violation was timely appealed.
Sandy, are you able to speak to some degree on that. I need to get this up on my computer, but
As to when they filed it, I do not have that in front of me, David, but
That's okay.
it was in time, or we would have had previous discussion about this.
I think
yeah,
it's dated
so
January 25th, if that helps.
it is, yeah, January.
26th. Yeah,
Yeah, but it was,
received.
yeah,
I don't know.
What is our deadline for that, Sandy? Is it what X number?
they
of
have, they've got 30 days to file an administrative appeal.
Okay, so January 4th was notice of violation. January 25th was when it was,
Right,
Always
but you don't count weekends and holidays.
right.
So they were literally at like their day 30.
How could they be on day 30 if that's dated January, if the notice violation was January 4, but was it received after January 25th?
It wasn't after January 25th, no.
Okay, so it's definitely within 30 days, because if it was issued on January 4th, January 25th, so that should be 3 weeks. So we should be good.
Yeah.
Okay, all right, very good.
Okay. We don't need a motion on that. I'll take findings of fact as consensus. And so the board next needs to determine that it has jurisdiction. So I suggest to you that this is an administrative appeal of a CEO enforcement decision. And that the board has jurisdiction under section 16 of its ordinance.
I would agree.
Everyone else on the board agree?
Yep, I'm in agreement.
Okay. I think we have a consensus on that. And obviously the subject of the notice of violation has standing unless anybody on the board disagrees with that.
Do not disagree.
And do we believe we have a complete appeal application?
I would agree.
Okay. I'm hearing a consensus on that as well. So that determines that the board has a quorum and jurisdiction to hear the appeal. So we'll move into I suggest that we move into the sequence of presentations here. So my recollection from last time, and certainly some correct me if I'm not recalling correctly, is that we'll begin with the appellant without interruption to present their appeal, followed by questions from the board to the appellant, followed by an opportunity for the code enforcement officer or other parties to ask questions of the appellant's witnesses. And then we will move into a presentation by the code enforcement officer without interruption. And then the same sequence of questions by the board, followed by questions by the appellant and other parties. Third, we'll move into questions and comments by the public and any other parties, and follow that with an opportunity for rebuttal by the parties, with the appellant having the last say. And then the board can, at that point, determine if it's ready to close the public hearing, and if it is, then move into deliberations. So, sorry for the interruption, but
I'm glad you
Mr.
did.
Chair, you were ahead of me, and you were right on to direct it to Attorney Ragin.
David, may I ask a quick question?
Of course you can.
Procedural question.
Yeah.
So I'm looking at the kind of numbered list of responses to the as part of the appeal. Or is this what is intended to be presented today, or is there a new version of this? I know that it's de novo, so I'm just wondering if it's appropriate to follow along with the original contents of the appeal, or is there a new version of this?
Is that a question directed to me, Greg, or?
I don't know. It's anybody that knows. I think it's maybe for Attorney Ratchin, since she's going to be presenting But,
Sure.
so, yeah, just some guidance on what I should be looking at would be helpful, I guess, is what I'm asking. Sorry for the confusion.
So, Mr. Chairman, may I address that?
Yes, you may.
Okay, thank you. First and foremost, I just wanted to say good evening to everyone. Nice to see you again. And everyone else, not just the board members, but everybody else out there. Mr. Dean, while absolutely, my original submissions back in January are a roadmap from the submissions that I'll be making, I'll certainly be, offering additional evidence. That was more in the nature of argument, but evidence and argument. And I think I'm hoping you saw that I had submitted something earlier today, which I'm hoping will be entered into the record. As I think Attorney Wagner had said at the outset, this is a de novo review. It contemplates oral and written evidence. So I'd respectfully request that that letter dated today from Mr. Goslin be admitted into the record.
The town doesn't object.
Do we need to move on that, Attorney Wagner, or?
Sure, we consistent with how we handled questions of evidence last time. Why don't we just do a quick motion to, this is the letter from the Q team principal.
Correct.
So do I have a motion to accept the letter provided by Q team through Leo P. Ratchin Esquire to be taken into the record? Do I have a motion to approve that?
So moved.
Seconds.
I'll second it.
Okay, any further discussion before we vote? So all those in favor of accepting this into the record, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
And Miller, yes.
Lockwood, yes.
Okay, very good.
And
Dave-
just, oh,
David, this is Tom.
Yeah,
Before we start on this process again, has anyone briefed Peter that we're really here only to prove that the code enforcement officer's violations are valid? That's truly the board's responsibility only in this thing?
but I believe Attorney Wagner, presented the roles of the ZBA with regards to this, taking it as de novo, listening to new evidence, and then at the responsibility of the appellant to bring forth the evidence. So Pete, are you comfortable with what your role is tonight?
I am. Thanks, Tom, for that question. But yeah, I did read over the information and I understood what Steve was saying, so I feel comfortable.
Okay.
If I may interject, I think I can, if I say something now, it's going to maybe expedite things just a little bit with regards to this appeal. In light of the letter from Aaron Goslin that has been put into the record, the town withdraws violations number 1 and 2 in the notice of violation directed to Q team relating to the Fernwood property.
Mr. Chairman, as I'm sure you can appreciate, that is not anything that Q team will object to. We'd be more than happy to have that with John, and certainly that would short circuit some of the arguments that I would be making this evening. So thank you for that. And if that is, we hear that on the record, I will not be addressing violations 1 and 2.
So Attorney Wagner, is there anything specifically on the board's end that we need to do for this?
No, I don't think so.
Okay, very good.
Just for clarification, Attorney Wagner, I'm assuming that that's going to be well reflected in the draft, in the findings and conclusions, correct?
Yes.
Yeah. Thank you. Okay, thanks so much. One thing I did want to do just before launching into the substance of our appeal is just a procedural reminder. Again, this is very much along the lines of trying to short, we appreciate your time. We understand that last hearing was a bit of a doozy. And in fact, I think we have the distinction of inspiring you to change your bylaws. So in light of that, we certainly appreciate that, time is important, and at least from our perspective, we're going to make every effort to try to streamline this. And to that point, I just want to make sure we get on the record my understanding, and I think we all agree, but I just want to make sure we do, that all of the prior arguments and all of the record evidence that was submitted on that first hearing in March are actually constitute the record for each subsequent appeal, so that we don't have to reintroduce them each time. My understanding is that all counsel of record agree to that, but I do want to make sure that that's on the record for this particular appeal.
I'm good with that. Attorney Wagner, is there anything you want to add to that for us before we go through?
I'm sorry, Leah, and I don't know if this is relevant for me or not. Can you please just repeat the statement so that I'm clear on what you're intending?
Yes. In preparation for this hearing, with the goal to try to keep this as efficient as humanly possible, I had heard the prior statements, and I think what was agreed is that all record evidence that was submitted in conjunction by all the parties in conjunction with the first hearing and also all of the arguments that were made also will apply to subsequent proceedings. And I think I see Attorney Wyckoff nodding. I'm hoping that you agree as well. And I think I saw the chair agree too, but obviously we want to make sure that that's clear for this particular appeal and all the ones going forward, that what was said, what was presented, that testimony, the documents, the records, and the arguments are all part of the record for each subsequent appeal.
All right, well, we're not currently a party to this proceeding here as it relates to your hearing, so I don't think I need to weigh in on that.
I guess from the town's perspective, I just want to point out that in the decision that has just been adopted by the board, what Attorney Rich has just stated is recited in that decision. So in fact, that is the case. The parties did agree to that previously, and the board has ratified that and included that in the decision that's just adopted.
Okay, well, accepting that then, without further ado, I'm just going to move forward. And again, in the interest of efficiency, if there are similar issues, similar arguments raised, I won't belabor those again. I will only address them to the extent that you might need your memory refreshed after 4 months. And also, if the facts of a particular case, like this one, are different from those, the prior one, then I'll highlight that as well. So without further ado, I'm just going to launch in. I'm Xing out things because given that the town's rescinding violations 1 and 2, a lot of the arguments I was going to make are no longer necessary. So just bear with me for a moment here. Okay, so as you may recall, one of our major arguments that we made in the prior proceedings, which this board did not accept, essentially, was that there are many duplicative violations here. And so I do need to renew those arguments for the record. I understand that you did not accept those arguments, but I am going to renew them just in order so that they are preserved for the record. And just to remind you, when I say duplicative, I mean that, and here we have 5 violations, 2 of which have been withdrawn. So now I'm focusing specifically on violations 3, 4, and 5. And those are, in essence, identical and verbatim to those, which I believe were 13 through 15 in the NOV to management control for the same property. So just to refresh your recollection there, 3, 4, and 5 were that there are unpermitted tree removal within 100 feet, vegetation removal, and again, also 5 was vegetation removal without a permit. And so I'm not going to belabor it, but I do need to refresh that and renew that argument that these are essentially the flip side of the same coin, and it is unfair to essentially not a double whammy, but a triple whammy for essentially the same activity. And one thing I did want to just, again, it's been 4 months, so I think this is a really important argument, and especially for your new member, I wanted to emphasize a point, is that I think what I had mentioned previously was that there is a provision in your ordinance that basically says if you're going to do a shoreline stabilization project, that you have to get planning board approval. And we absolutely have stipulated to the fact that there was no planning board approval sought or granted. But the core of the argument is that had they done that, which was the proper way to go, then all of these sort of individual discrete violations or alleged violations, such as tree removal, vegetation removal without a permit, would have been subsumed into this one permit. And so instead of characterizing one mistake, which we admit that Mr. Durant or his entities made, instead of looking at that as one mistake, what the town has done essentially is to look at it or morph it into a series of multiple duplicative mistakes. And the question here is, why is it important? It's absolutely true. We've discussed this at length last time, that this board, we acknowledge, has no authority over the issuance of fines. But it still is critically important what you decide here, because as you may know, if this goes to court, the court has discretion to issue fines based on a per day, per violation basis. And so instead of one violation, if we're looking at 3 or 4 or 5 or 12, as the case may be, as the town has alleged in some of these appeals, then you can see that the magnitude of impact here is exponential. And so it's important for you to understand, you know, the magnitude of your decision here. I think, frankly, given the fact that the violations 1 or 2 have been withdrawn, that's in essence what my argument is. But I would like actually, you know what? I don't need to. That's it. We're going to rest. So ultimately, violations 1 and 2 have been withdrawn. The essence of our argument is that the remaining violations, all of which involve vegetation removal, tree removal without a permit, they are all subsumed into the same, in essence, activity, and therefore should not be 3 separate violations, but 1. And so I thank you for your time and attention. Happy to answer any questions from the board with respect to our appeal.
Fellow board members, do you have any immediate questions for Attorney Rotchen?
So just to clarify, it's what you're saying is 5 is duplicative of violation 1 and 2, and 3 and 4 are duplicative of each other. Is that, am I getting that right?
I'm sorry, Mr. Dean, would you mind repeating that if you would?
Yeah, I think what you're saying is that, as I understood the duplicative argument to be that violation 5, and this is a duplicate of violations 1 and 2.
Correct.
Violation 3 and 4 are duplicates as a separate set of duplicates.
Yes, and I would add 5 also into that second set. So 1, 2, and 5, because 5 is doing the activity without a permit. So I would say that's subsumed into 1 and 2, but
Right.
also 3 and 4, 5 is also duplicative. So the groupings are 1, 2, and 5, 3, 4, and 5.
Okay.
Thank you so much.
Anyone else?
Attorney Murch, if I can just ask a clarifying question to Attorney Rachin.
Sure, of course.
I think I'm belaboring the point, so I apologize for that, but just so I can confirm, you are still relying, am I correct to say you are still relying and have not conceded the argument about Q Team's reasonable reliance on Big Lake Marine?
Absolutely have, yes. And because when I hear that the violations 1 and 2, the removal of vegetation of less than 3 feet in height, the removal of that violation, I think, and I don't want to actually assume anything, you know what they say about assuming, but if I can clarify that the reason why those are withdrawn is because they did not conduct that activity, rather somebody else did. I'm hoping that that's the basis of it, because that is what our letter today had outlined. But with respect to, we are not waiving in any way the broader idea, which I think is what you're getting at, Attorney Wagner, is that, you know, if we, and I can bring this invoice up if you'll indulge me. Can I share my screen for a moment? Do I have the capacity to do that, Mr. Chairman?
I'm fine with that. I just,
Okay,
Raymond office needs to let you
great.
do it.
Are you able to see the screen?
Yes.
Okay,
See.
so this right here, and this I think has already been in evidence, but this is the invoice for the job at, you can see here, 18 Fernwood, right? And that's between my client Management Controls and Big Lake Marine Construction. And you see here, the language is that here, Big Lake Marine will obtain all necessary permitting from town and DEP. And so absolutely our client is, when I say our client, I'm saying Q Team, you know, their submission is that, look, they went in and did this work, but they were absolutely under the impression that all necessary permitting from the town had already been secured. So yes, we are not in any way waiving that argument. We are relying upon it. And I thank you, Mr. Wagner, for identifying that.
That was all I had. Thank you.
I just need I'm just clarifying what our next step is. I believe we're to turn this over to Alex. Is that correct, Attorney Wagner?
You're muted, Mr. Wagner.
Yeah, I see that. So yeah, we've had questions from the board. I would turn it over, I guess, if there was no witness testimony here. So unless there's an objection, I don't think we need to turn it over to the Attorney Wyckoff for any questions. So the next step would be to turn it over to Attorney Wyckoff for his presentation without interruption.
Very good. Thank you. I'm happy to do that. Let me first of all, thank you all very much for making yourselves available. You know, it's an important thing that you're doing and an important duty that you're carrying out for your community. So I just want to thank you for that. Let me first begin addressing the last argument that Attorney Rachel made for Q Team, that Q Team relied on Big Lake Marine Construction to get all the permits for the tree removal. As we heard her just say, that relies on an agreement that was between the Management Controls and Big Lake Marine, that Big Lake Marine was going to obtain permits. You know, the town isn't a party to that agreement. The issue here is whether Q Team engaged in conduct which violates the shoreline zoning ordinance. So that's the important concept to keep an eye on. And whether Q Team had any kind of arrangement with anyone else to obtain a permit isn't relevant to whether Q Team engaged in any violation. So for that reason, you should reject this argument, much in the same way that you rejected the argument that was made by Management Controls with regards to Fernwood in its appeal. Then let me move on next to the argument relating to violations 3, 4, and 5 being duplicative. So violation 3 is for removal of trees to create an opening in the canopy greater than 250 square feet. And that violation relies on section 5Q2 of the shoreline zoning ordinance. So that's violation 3. Violation 4 is is a violation of the provision in the shoreline zoning ordinance that provides that in order to that the ordinance prohibits the removal of vegetation in excess of what is allowed by the point system, and it's relating to selective cutting requirements, and that's contained at section 15Q2B. And then violation 5 is for removal of vegetation, in this case trees, without a permit from the code enforcement officer. So though, and that relies on section 14 of the shoreline zoning ordinance, which is the table at line 5. So those 3 violations all rely upon 3 different provisions contained in the shoreline zoning ordinance. And now, for the same reasons that you have that you upheld violations 13 and 14 in the notice of violation to management controls relating to Fernwood, you should uphold this you should uphold these 3 violations as well, and that these violations are separate violations. So now, one of the arguments here, I think, is that there was removal of hazard trees. That argument shouldn't be heard because those issues would have been considered by the code enforcement officer had it consulted, as required by the shoreline zoning ordinance. That only didn't occur. So you should not credit that that contention at all. And with that, what I'd like to do is I'd like to turn things over to Alex. I'd like to have Alex just walk us through what constitutes violations 3, 4, and 5.
All right. Hey guys. So I have my slides that I used for the last time we discussed this particular appeal. I'm going to pull those up for the violations specific to Q-Team. I'm just wondering, David, would you like me to jump right in at the Q-Team stuff, or would it be helpful for you guys to recap any of the history with this?
I think a brief recap of history would be beneficial just for everyone.
Yeah, yeah, that's no problem at all. So let me just pull that up. What I may do is I may skip some of the slides that aren't relevant once we get past the kind of the introductory information here. So I'm going to share my screen now. So hopefully a lot of this is just recap from last time, but I think it's good to kind of go through some of it again. This violation was reported to the code office by Alexis Savavlos from Maine DEP. After a day out on the lake, she had noticed the work was taking place on 18 Fernwood and 28 Whitetail. And she sent us this photo in an email asking if we were aware of the project and if it had received a permit from the town, which it had not. Following that email from Alexis, like I said, we checked our records, was not able to find a permit that had been approved or submitted to the office. We were able to then complete a site inspection with Portland Water District, Rob Durant, and DEP, and we took photos of the site as we found it that day. Here we get into the violation, so I'm going to skip ahead here to the tree specific violations. These should all look familiar, of course, from last time. None of this information has changed at all since that last meeting. All right, so this is where we start vegetation removal. This was one of the items that we have withdrawn, which was vegetation removal less than 3 feet in height. So I'm going to move through these quickly as well. I do feel like the photos do help though to see the site. And this is the hot tub, which is not relevant for this. All right, so now we get into the trees. This is the work that we understand was done by Q team. These are the trees in front of the house that have been removed. What they have accomplished by doing this, removing these trees here, which are shown in the red box, 1, 2, 3, 4, and 5, they've created a canopy opening in excess of 250 square feet, which is the first violation. Again, you'll see on the other side, there were other trees that were removed in order to complete the shoreline stabilization, which also increased the amount of opening in the canopy. You can see here, green circle is showing the area where canopy has been removed and a new opening has been created in here on the other side as well. So in addition to that, we also have a violation for removing in excess of what's allowed by the point system. So tree removal in the shoreland zone can be done by one of two methods. Either a tree is considered a hazard tree and it can be removed, or it meets the selective removal requirements. So the way that works is we have to establish 25 by 50 foot grids, and each tree is given a point based on the diameter of the tree at 4.5 feet. A homeowner or a contractor doing the work has to maintain 24 points within each 25 by 50 foot grid. So by removing vegetation in the front lawn area, we estimate that there were at least 3 grids of 25 by 50 where they removed essentially all of the trees, which would be clearly violating the requirement to maintain at least 24 points, because now they no longer have any points in those 3 grids. So that would be the second of the 3 that we're keeping. That's the end of the slideshow, but the last of the 3 Eric will get into, which is the tree removal without a permit.
That's right. So section 14 of the shoreline zoning ordinance at line 4 states that when vegetation is removed, which includes trees, that a permit is required. And as Alice stated, there have been trees that were removed within that zone, and there was a permit for that. And in fact, in the letter from Aaron Goslin, he acknowledges removing trees 1 through 4 and trees 14 and 15. So it's clear that that version of the shoreline zoning ordinance was violated, and for those reasons, violations 3, 4, and 5 are independent violations. They're not duplicative. They don't rely on one another. They're really separate violations. Thank you.
I do not have any questions. Fellow board members, do you have any questions for either Alex or Attorney Wyckoff?
And I have a quick question. I'm still trying to wrap my head around how to word it, but I think I recall this is a pretty tricky one. Is there a way to violate just 5 and not, yeah, I guess what I'm saying is, there an example of how you could violate 3 or 4 without violating 5? Like, you can just walk me through a hypothetical example of how these could be independent violations. Because if you had a permit, I don't see how you could be in violation of some other permit, other requirement to have a permit. So that's what I'm having trouble kind of, understanding the logic there. So.
Yeah, is that question to me, Greg?
I believe so. Although,
yeah,
I'll open it to either you or Attorney Wyckoff if.
Yeah, I mean, I'll take a stab at that. I mean, it is a difficult thing to try and wrap your head around, but the way that I kind of look at it is, and maybe this will make it worse, I don't know, but Let's say you build a house and that house has code violations. You know, let's say there's a second floor deck that has no rails. And we all know that if you're going to have a second floor deck, you're going to need fall protection. So to make it worse, they built the house without permits. So to say that they have to all be lumped would kind of be like saying, because you didn't get a permit for the house, there's also no other violations because we can't lump them all in, is kind of how I look at that. There can be numerous violations and also be in violation for not having a permit because the ordinance has multiple different sections, and one of the sections is permits required. And then there's also some more technical sections in the ordinance that have specific standards for land use. So someone might be able to get a permit for tree removal in the shoreland zone and then exceed what is allowed by the permit. That could be a scenario. I think you're kind of going down that path right now where they might have a permit to remove trees, but they actually exceed what the permit allows. I think that could be a possible outcome. But the house scenario is how I look at it. Just because someone doesn't get a permit for something that has multiple violations, I don't really think you can throw the rest of the violations out all because they just didn't get a permit.
And I guess the only thing I would add to that is each of those violations, 3, 4, and 5, they rely on separate provisions of the shoreline zoning ordinance. So, I mean, there's distinct provisions there, each of which have been violated.
Well, yeah, I guess I might be questioning the logical consistency of how that combination of violations could coexist separately, but I understand your point. Okay, yeah, I think that's it. I just.
Anyone else? Tom, Fred, Pete?
David, are we doing the same process that we did the last time 4 months ago, that Attorney Wagner's gonna say something and we're gonna vote yay or nay?
That was the assumption that I was going with.
I'm just trying to move ahead here, so.
Okay.
Yeah, so if I can just, that would come in during the deliberation section.
But Mr. Chairman, I think that if I understood the order of operations, and I understand Member Hennessy's desire to move things along, but I think that part of the process is allowing, I haven't had my chance to ask my questions of the code enforcement officer.
Yep.
So I'd like to take that, and it's brief, but due process dictates that I get that chance, if I might.
Yeah, and I agree, and I don't think Tom was indicating a desire to jump over that. I think he's just trying to figure out the overall process. So, yeah, Attorney Ration, if you would like to go ahead and respond.
Very couple questions. That's it, and a few comments after that, and that's it for me. Is it okay if I call you Alex? Is that all right?
Absolutely, yeah.
Thank you. Okay. So very quickly, you're not an arborist, right? Is that not part of your training as a code officer, correct?
No, I'm not an arborist. No.
Okay. And with respect to this, the hazard tree provision in the ordinance, which I understand does not require a permit, but does require consultation, correct?
Correct.
And as I understand it, that process the town uses is that if somebody does want to remove a hazard tree, that you would request that they get an opinion from an actual certified arborist to say, yep, it's a hazard tree, and perhaps why. Is that fair?
Yeah, if it's unclear that a tree is a hazard just from, going out and looking at it saying, yeah, that's dead, dying, or dangerous, then it is common that we may ask for a hazard tree assessment from a qualified professional. Yep.
Okay. And in this case, are you aware of, do you know Mr. Goslin?
Yes.
And my understanding is fairly, I can't give you numbers, but fairly regularly he issues opinions with respect to whether or not something is a hazard tree.
Yeah, it's actually something that, so it was common for companies that do tree removal to do their own hazard tree assessments for a number of years. But a few years ago, DEP actually, at a training, suggested that all code officers, when they're issuing permits for tree removal, if it's a hazard tree, that the hazard tree assessment should not come from the professional that profits from the tree removal. So, and Aaron and I actually discussed this when I was in a previous town that he did a lot of work in. I suggested that he actually find another company to kind of trade with so that they could make it easier to do that, so that it wasn't, he would do a hazard tree assessment for another company and another company would do it for him, just so that it was very clear that there was no conflict. We haven't had to do, as far as I can remember, we haven't had to do any hazard tree assessments with Q Team in the last year or two that I know of. But that's the process that we've tried to follow.
Okay, and so this was part of a training, but is there any regulation or ordinance provision or anything like that that actually requires that somebody else do it?
I'm not sure. Yeah, I don't know if there is anything in writing anywhere at the state. I know there definitely isn't in our ordinance. Like I said, that was just something that was provided to us from Jeff Kalinich, our shoreland zoning coordinator for this area.
And any reason, in your dealings with Q Team or Mr. Gosling to question his integrity that he might, not be forthright just because he's doing the work?
No, I have not had any issues with that. I do generally trust, Aaron's judgment when it comes to that.
Okay, and I just want to go back, if I can, share my screen again, Mr. Chair. Is that okay?
Yes.
Thank you. Can you see the image that I have here with the trees and the boxes?
Yeah.
Okay, and so as you saw in the letter that was submitted today, Mr. Gosling, who's a certified arborist, had discussed how these 4 trees, 1 through 4, in his expert opinion, were in fact hazard trees. If you can see here, according to his expert opinion, this dead area here, dead area here, dead area here, that these were hazard trees. And so, I understand that there was a consultation piece required, but as a certified arborist, if he had given you this information and now that you have it and you have these photos, any reason to believe that he's incorrect?
I would say, just looking at these photos, I can't say for sure that I would agree that they are hazards. If it had come down to it and we had done a consultation and looked at them on site, it probably would have been a situation where we would have asked for a hazard tree assessment. And we may have got that from another company and they could have agreed, but they could have disagreed. Unfortunately, we don't know because we weren't called to go do that that hazard tree consultation, I guess, if you want to call it. It's kind of suspect. 4 and 5 for sure. There's really not a whole lot from this photo that we can tell. 2, like you're saying, yeah, there's some spots that do look dead.
Right. I just want to correct one thing, though. I think we're not talking about 5. We said 1 through 4. As his letter indicated, that the removal of a lot of these trees was not something that he did. But I guess suffice it to say, I hear your testimony is that you are not a certified arborist. You had an opinion from a certified arborist who said that these were, and I just wanted to confirm those 2 facts.
Yes.
Okay, and that's it. That's all I've got.
Last question again. I was confused by your last question. Could you repeat it, please?
I can't. I don't remember what my last question is. Frankly, I'm so sorry.
I thought I heard you ask him that whether he had an opinion from a certified arborist that these were hazard trees.
No, whether I said he had an opinion. Okay. He has an opinion. I understand, Attorney Wyckoff, that you're asking me if he had an opinion prior to, and the answer, of course, to that is no. I'm saying right here, right now, we have an opinion from a certified arborist who is saying that these were, in his professional estimation, hazard trees, and that I heard the code enforcement officer say that he's had no reason to question Mr. Gosselin's integrity, his professionalism, his expertise, and that for whatever reason, he thinks that he disagrees. That's the testimony, as I understand it, unless Alex, you want to correct that.
Yeah, I mean, I would say that I don't. We didn't really have the opportunity to weigh in. I think if we had the opportunity to weigh in, things could have gone differently. Unfortunately, the ordinance is the ordinance, and it's written the way it's written, and we have to enforce what's written. So, were we called to do a consult on site to view the trees before they were cut? No. Were they cut without a permit? Yes. I mean, unfortunately, the ordinance is the ordinance, regardless of what type of history we have with the contractor or what their reputation is. If we start to just trust reputations, it gets a little bit messy.
Fair enough. But one last question: in the I don't know how many years have you been with the town, Alex?
I've been with Raymond for 2 years.
Did you say two? Is that what you said? I'm sorry.
Correct. Yep, 2 years.
And in that time, or if you're aware, any other further time in the 20 years that Mr. Gosselin's been doing this, have you or any other code officer that you're aware of rejected an opinion of his with respect to whether something was a hazard tree or not?
I do believe we have denied permits for tree removal. I don't know specifically a number or if that denial was for a hazard tree or if it was selective removal. I do believe we actually did have a recent denial for tree removal.
Are you saying, just to be clear, I just want to make sure the evidence is clear. Are you saying generally speaking or with respect to Mr. Gosselin? Because I would submit to you his testimony would be that never.
Give the answer. Let him testify.
Well, it's in his letter, actually. That's in evidence. So.
Yeah, but I believe he's saying that he's never had any violations, right?
He did in fact say that, but if I can share my screen. Are you seeing this letter?
Yes.
Okay. I believe he indicated that the second to last sentence in the last bullet, I have provided such opinions many times to the town's code enforcement officers, and they have never disagreed with my determination. So that is in evidence. And I'll just leave it there. There's no need to belabor it. Those are my questions.
Why don't you ask Alex what his testimony was?
I did.
And okay. Are you trying to refute it with the letter?
No, I think everybody's testimony speaks for itself, and I will rest on those questions.
Yeah, I guess if I could respond to that, I would just say that the town of Raymond and my department definitely does not rely on our relationships with professionals when it comes to issuing permits or allowing permits or work to take place without permits. It's a case-by-case situation. Each permit's reviewed as it comes in. And while I definitely respect Aaron and Q team, this is the first situation I think I've run into with them where they actually relied on someone else to get their permit. Typically, they get their own permits for everything. And coincidentally, we have an issue. So it was definitely concerning for us to see this, and it's definitely disappointing.
So I'm all set, Mr. Chairman. Thank you.
Okay, thank you. Board members, any final questions before we go to public?
Actually, Mr. Chairman, may I ask Alex a few rebuttal questions, please?
That would be fine.
Alex, were you consulted about removing any hazard trees as required by the shoreline zoning ordinance?
No.
Now, if you had been consulted, what would you have done?
So we would have gone out to do an inspection, and if a tree identified was either dead, dying, or clearly dangerous, we would have issued a permit for tree removal. And if there's not established growth in the area where that tree was being cut, we would have required replanting. As part of an issued permit, there would have been conditions for replanting.
Did you ever have the opportunity to go and inspect these trees?
I did not.
Okay. Now, let's assume that the tree was a hazard tree. Would removal of these trees as it occurred have complied with the shoreline zoning ordinance?
If they were hazard trees, yes, they would have.
Now, but what does the ordinance provide with regards to stumps?
So stumps within 100 feet typically cannot be removed.
Okay.
There are certain situations where they can, like if someone's building a house. So if it's for an allowed use and there's excavation taking place and they need to remove the stump for that, then that would make sense and that's allowed. But in a normal situation, they can grind the stump down, but they cannot remove it.
Okay. What happened here?
We are not clear that there's any stumps in place. It does not appear as though they retain the stumps. There was a significant amount of soil disturbance and regrading that took place on the site, and there's multiple spots where the ground is very soft, where there was once trees. So our belief is that stumps have been removed.
Thank you. I don't have any other questions.
Okay, unless the board has any further questions, I'm going to move to opening up public comment. Greg, you got something?
Yeah, quick question with respect to, I understand the point system, and that's the hazard trees are kind of an exception from the requisite points. Does that also apply to the canopy? If there's a hazard tree, does it count against the square footage requirement for the canopy, or are they mutually exclusive kind of concepts?
No, a hazard tree, like I said to open, there's really two methods for removing trees. It's selective or hazard. And if it's a hazard tree, it can be removed regardless of the point system or the canopy. You just may need to replant.
Okay, thanks.
All right, I'm going to go ahead and open this up to public comments. Is there anybody here tonight from the public that would like to speak for this application, this appeal? Is there anyone here from the public tonight that would like to speak in opposition to this administrative appeal? Finally, is there anyone here tonight that would like to speak from a neutral perspective in regards to this administrative appeal? Seeing and hearing nothing, I'll go ahead and close out public comments. Attorney Wagner, I believe we are now into our own deliberations as a board. Would that be correct?
Well, I think that just ask if any of the parties have any final overall rebuttal statements or closing arguments. I'm seeing shaking heads. Okay, so then the next step for the board would be to vote to close the public hearing and record and then proceed into deliberations.
Okay, do I have a motion to do that?
So moved.
Second.
Further discussion by the board before we vote? All those in favor? David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, very good. Attorney Wagner, I remember this process somewhat, but if you want to help guide us through it, that would be appreciated.
Absolutely. So I'll try to have as light of a touch as I can. That's my gentle practice, is to really defer you all to make the factual findings and conclusions, but I can certainly guide you. At this point, the record's closed, so you have the evidence. That includes what was presented today, everything you've received, everything that was in the record for the last appeal, and I would also encourage you to take a look at your findings and conclusions of that last appeal, because I suggest to you that unless you see some difference in the facts here, or some reason to distinguish the two situations, in my opinion, it would be reasonable to carry over your same factual findings and conclusions again, unless there's some difference here, then we should talk about that, or the board should talk about that. So in terms of the order you want to take it up, we have last time the board to some extent relied on the proposed findings of fact of the town and compared that to the appeal packet by Attorney Rachin, and looked also at the notice of violation and sort of worked our way down, so we could do that again.
That sounds good.
Oh, if you give me a second, I've got the wrong document in front of me. Okay. So I think the first issue for the board to weigh into is whether all the violations here, which as 1 and 2 have essentially been dismissed, we're dealing with 3, 4, and 5, should be vacated because Q-Team reasonably relied on the property owner's contractor to obtain all required permits consistent with and act consistent with the shoreline zoning ordinance.
Yeah, that's a good point. I remember us discussing this last time. And while I do agree that there's an expectation of a party to get the permitting, there's also reasonable part to that, a responsibility to ensure that permitting has been obtained before moving forward with work. So my opinion is it should not be vacated because permitting was not obtained by another party. The board members, if I can get your comments, it would be appreciated.
Yeah, I'll kind of second that. I think while there might be reasonable recourse for some sort of contract between the two parties, I'm not sure it's our job to interpret and try to unwind that contract. And whoever did the work seems like is responsible for the violation.
Yep.
I think I agree also with that, especially with the Q team is very familiar with, the process of what happens, when trees are being removed. And especially if it sounds like they have somewhat of a relationship with the code enforcement officers in the local towns that, that they would have, went to them to make sure that there was permits pulled for what they were doing.
Tom, do you have something?
I guess my opinion would be that the responsible party, they cut things down, is responsible to have the permit in hand and also do the consultation with the code enforcement officer. So I don't see any reason we should be supporting, I'll say, the finger pointing between different companies. That's not our job.
Anything, Pete?
Yeah, I agree as well, David. I think that Q team is obviously familiar enough with this process that they should have been involved as far as making sure that the permitting was in place and that they had been in touch with the code enforcement officer.
Okay. So, Attorney Wagner, is it a motion at this point?
So let me ask 2 questions. So
Sure.
you all heard each other's reasons. Do you all generally agree with each other? And you can just nod your heads. I'll a consensus from that.
Yeah.
So I think there's consensus on all those being the findings and the reasons. Second question, I'm looking at the decision from the management controls in there, and as you know, the parties have agreed, and it's part of the law of this case essentially, that they are also relying on the arguments that are made there to the extent that they're applicable here. So I ask that you all look at those draft decisions and that draft decision, let me know if your findings and reasonings in response to those arguments, and that was in part one of that decision, apply equally here, or if you don't think they do.
Believe that they do, but gentlemen.
I'm sorry, David. Attorney Wag, I'm not sure I understand what part you're referring to. Part one of.
So I'm asking you to compare, to reference the arguments. So if you look at the draft decision for the management controls, it's got a summary of the town's position and the arguments that the management controls made, and then it goes into the board's factual findings and how it responds to some of those arguments. For instance, it talks about 30A MRS 4452. It talks about 38 MRS 444. And so my question to you is that do you still have the same opinion about those arguments? Because, and the reason I'm asking that is the parties are still relying on those arguments, even though they haven't repeated them today.
Right. Okay.
I'm just reviewing our document. Yeah, I don't disagree with. I don't see any discrepancy with what there. What is there now? What is it? What was written up with tonight? I don't see a discrepancy.
The only one I would suggest to you to consider would be, for instance, the relevancy of 30A MRS 4452, which talks about owner liability for violations.
Got it. So I guess in this case, there is a difference in the sense that we have one contractor in conjunction with another contractor. But in even reviewing this, I mean, if it's not this contractor needed to ensure that there were obtained permits. So I guess I'm not 100% sure, Attorney Wagner, what you're looking for from us here. Overall, I believe the board's in agreement that we, this particular contractor should have evidence permits before moving forward with the work, because they did work without a permit.
Okay, no, I think I've got clear direction from the board.
Okay.
This applies equally. We have an agent principal relationship. You still believe section 2 of 4452 applies? Okay. So I think I have a clear understanding there. So unless there's further discussion, I would suggest a motion that the board concludes. Motion that the board concludes that because Q Team is responsible for its conduct in violation of the shoreline zoning ordinance, the CEO did not err and all violations are not vacated on the grounds that Q Team is not a responsible party.
So moved. Do I have a second?
Can you just say the last part of that again?
Yeah.
He just said that QT.
And therefore, all violations are not vacated on the grounds that QT is not a responsible party.
I'll second that.
Any further discussion before vote? All those in favor, David Murch, yes.
Brendan, yes.
Tom Hennessy, yes.
Pete,
Lee Lockwood, yes.
be unanimous.
So
we have,
oh, sorry, Mr. Chair, if you wanted to direct it, I'm happy to turn it over.
well, yeah, no, I'm just looking at this. So I'm believing them, we're moving on. Since 1 and 2 are vacated. Well, the next step is to look at item number 3.
Yeah.
And prevented tree removal within 100 feet of Sebago Lake. It's my understanding, Attorney Wagner, that we can review our decision and look for any consistencies or inconsistencies with that. Or I should say inconsistencies. Are we consistent with our decision from last time? Is that correct?
Yeah, so what I'm hearing you saying is that moving on to the issue of whether violations, so you're taking it just violation 3, or are you looking at 3 and 4?
I would, yeah, 3 and 4.
Okay. So that concerns removal of alleged hazard trees, and the argument is that should be vacated. And then so your question is, can you start by looking at to what extent you made relevant findings and conclusions in your management controls decision? And I think that's a fine place to start with that.
Great. So if I'm reading this. So this would, looking at our decision, I believe this, gentlemen, you're gonna have to help me out here. This should correspond to item 11, whether violations 14 and 15 should be rejected. Or conclude similar to reasons above that these are separate violations. Violation 14 is based on 15 Q2B. And there we see here. I'm trying to Q2.
So
Cross reference would be ideal here.
rewinding it a little bit.
Yeah.
And Rich, why don't you start the basic facts here? So, just again, we look at the notice of violation. So 3 concerns the section 15Q of the shoreline zoning ordinance, and
Q2A.
Yeah, 15Q2. Yeah, A.
Yeah.
And so
we have
findings you want to make is, who's the party that made the conduct, and is there evidence to show that conduct violates that section?
Right. So I just want to make sure my board members are tracking with me here. So you have the ordinance up in front of you, or at least what was written up in terms of the for 15 Q2B or Q2A. I just want to make sure we're all on the same page here before we go too far along here. I need a confirmation verbal confirmation, yes or no?
Yeah, I have the 15 QA. Opening grade of 250 square feet.
Tom, Greg, Pete, how are you tracking there?
Yeah, I'm with you.
Okay, Tom, you good? You,
I'm with you.
all right. Pete, you good too?
I'm with you too.
All
Dave.
right, all right. So we've got our ordinance here. We got 15Q2A. There shall be no cleared opening greater than 250 square feet in the forest canopy other than existing wooding vegetation if a forest canopy is not present as measured from the outer limits of the tree or shrub crown. However, a footpath not to exceed 6 feet in width as measured between the tree trunks and or shrub stems is allowed for accessing the shoreline, provided that a cleared line of sight to the water through the buffer strip is not crowded. I also think it's important to review about the hazard trees. Yeah, I kind of want to touch on the hazard trees. I do think the ordinance is kind of straightforward in regards to that. Hazard trees in the shoreline zone may be removed without a permit after consultation with the CEO if the following requirements are met. I think I think Attorney Ratchet makes a good point about the potential for hazard trees, but it was also admitted that there was no consultation with the CEO prior to the trees being cut down. So whether they were hazardous or not kind of is a moot point in regards to that.
Yeah, I sort of tracking with you on that. I think what happened, I assume we're open discussion at this point, but
Yeah, please.
You know, had there been a permit, there would have been a consultation, then all of a sudden the arborist opinion would be pretty meaningful. And my understanding is that the consultation is a prerequisite for the permit. It's kind of unfortunate if Q team assumed there was a permit. They could have very reasonably thought that their opinion, which is qualified, that their hazard trees would kind of obviate 3 and 4, or at least kind of you know, meet the criteria for them to kind of lawfully remove the trees. But I don't think it actually changes what happened, whether it's unfortunate or not. Just kind of inferring from the evidence, especially their letter that was submitted. So yeah, I think it still stands as we kind of understood it.
Yeah, but plus to confirm how it's written, it says hazard trees in the shoreline may be removed without a permit after consultation with the CEO if the following requirements are met.
And you want to just read those requirements?
Sure, of course. Within the shoreline buffer, if the removal of a hazard tree results in a cleared opening in the tree canopy greater than 250 square feet, replacement with native tree species is required unless there is new tree growth already present. New tree growth must be as near as practical to where the hazard was removed and be at least 2 inches in diameter, measured at 4 1/2 feet above the ground level. If new growth is not present, then replacement trees shall consist of a native species and be at least 4 feet in height and be no less than 2 inches in diameter. Stumps may not be removed. So basically the trees, if I'm reading this correctly, hazard trees can be removed, but then they have to be replaced.
Yeah, removed, no permit, with consultation, and need to be kind of replanted, or something needs to be replanted. Yeah.
Yep.
Yeah. Of which none of that happened. There's no consultation, there's no permit, and there was no replanting.
Right.
So it's kind of a slam dunk on not meeting those requirements.
Right. Yep. And then at least with regards to the hazard trees.
Yeah.
So now the next question is, we can bump it up to unpermitted tree removal within 100 feet of Spega Lake. Except in the areas described, well, there shall be no cleared opening greater than 250 square feet in the forested canopy. So I've already reviewed this. I believe Alex's presentation makes it clear that there was an opening cleared of greater than 250 square feet. So, I don't believe we should vacate this particular item. But
Great.
Gentlemen, is everybody else sort of the same mindset here?
I agree.
I don't see us relieving any of these violations.
Okay.
Well,
So Attorney Wagner, for at least, I guess we have bunched in number 4. We added number 4 to this too. So number 4, vegetation removal in excess of what is allowed by the point system. This goes to shoreline zoning provisions, section 15Q 2B. Selective cutting of trees within the buffer strip is allowed, provided there is a well-distributed stand of trees and other natural vegetation is maintained. For the purposes of this section, well-distributed stand of trees adjacent to a great pond or a river or stream flowing to a great pond shall be defined as maintaining a rating score of 24 or more in each 25-foot by 50-foot rectangular, 1,250 square feet area as determined by the following rating system. Yeah, so again, given Alex's presentation, what was seen, I don't see this as a duplicate of number 3. I just see it as two sections of the ordinances being violated. The first one being 15Q2A, the second being 15Q2B. So 2A, and then separately, this one is 2B. So I don't see it as a separate item. I do see it as a separate item, not just because they fall under 15Q2. We have an A and a B to consider. I mean, this is letter B. But I welcome any feedback.
I think you got it. I'm
Agree.
in line with what you just said.
Does anybody see any reason to vacate this? If not, I believe this one should not be vacated as well. So all right. So Attorney Wagner is the next step. To me, it seems like, are we voting on whether 3 and 4 should be vacated or not?
Yes, I think you're voting as to conclude that you uphold violations 3 and 4, finding there to be sufficient evidence that the violations occurred and based on the conduct of QT.
So moved on this, anybody? I'm sharing the wealth here.
So moved.
Second.
Second.
Okay, any further discussion before we vote on this one? All those in favor? David, yes.
Greg Dean, yes.
I'm gonna say yes.
Another yes.
Lockwood, yes.
All right. So that moves us on to the last one. Number 5, removal of vegetation without a permit, falls under shoreline zoning provisions, section 14, table of land uses, number 5, clearing or removal of vegetation for activities other than timber harvesting, which is a requirement of a permit. So there was no permit here. I think this one, to me, is pretty straightforward. Everybody seeing something here differently?
If I can just interject on this one, Chairman Murch,
Yeah, please.
I don't think that Q team is challenging 5 necessarily. I think what their argument is that 5 should be subsumed into 1 and 2.
Ooh, gotcha.
So I think how I would phrase the issue is that violations 1, 2, and 5 should be vacated or consolidated because they are duplicative. And I think that's the question that the board should address.
I just wanted to interject. Violations 1 and 2 have been withdrawn.
I'm sorry, yeah, so I guess now I'll modify my notes, whether violation 5 should be vacated or consolidated. Thank you, Attorney Wyckoff.
And if I might just, I actually agree with Attorney Wyckoff that 1, 2, and 5 we had argued should be consolidated. And as you said, the second argument was 3, 4, and 5 should be consolidated. Thank you.
Yeah, thank you, Attorney Ratchin. I remember that as well. 3, 4, and 5 consolidated, which we didn't do, so we're going to consider it separately. But in light of that, gentlemen, thoughts?
I don't know, I think I'm in maybe the minority here, but I struggle with these kind of omnibus, you require a permit because of these other things that make you require a permit, and therefore we send you a couple violations on essentially the same thing. I've yet to hear like an example of how you could not be in instant violation of 2 as soon as you're in violation of something that requires a permit. Like it just seems, I perpetually struggle with this, and I did last time, I think on 7 and 8, if I recall correctly, or maybe not 7 and 8, but there was a pair of violations. I think it's, I don't know. It's not as clear to me that this is a unique violation.
I'm looking at the old decision, and I do think on 7 and 8, that issue was a 3-1 vote. So
Okay.
you came down on that.
Yeah. So I think for similar reasons, you know, it just seems a pretty high bar if you're instantly in violation of not having a permit if you don't have a permit. That seems pretty like the ordinances that make you need a permit are also, you know, offenses or violations that you can be cited for. I just, you know, I know Alex gave the building a house example, but I don't know. That's just my thoughts. I'm loosely held opinion, but that's kind of where I'm at.
I guess from the letter we got from Q-Team, they admit they didn't have a permit, and it seemed like they were recognizing that, and I don't think they ever disputed that. So, so I don't see how we can vacate that violation.
Yeah, I kind of fall black and white on that one too. Fred,
I
Pete,
feel the same way too. Yeah.
Same way.
Yeah.
Same way. In what way, Fred?
I think that the violation should stand.
Any thoughts on this, Pete?
Yeah, I agree as well. I mean, it's pretty clear that they should have had a permit.
You know, so just why do they need a permit? Because of the ordinances that they're in violation of, correct? Is that the correct thinking?
Violation 5 refers to section 14, number 5.
Yeah, so the land use ordinance, the table of land uses, sorry. Number 5.
Yeah.
So it's almost, my flow of thought is number 1, it's almost like number 5 should have been the first thing. You know, you did this removal of vegetation without a permit. That's issue number 1. Then you move on, and then we have unpermitted tree removal. Okay, you didn't get a permit, you didn't get the permit, that's number one. Now what, because of that, and now if we look at it, unpermitted tree removal is number two. Sort of like the follow-up to it. So I kind of get what you're saying, Greg, but I still can see them as separate and distinct. Because it's one is the vegetation removal, and then you have vegetation removal within 100 feet of Sevago Lake. So they're, to me, they're distinct enough. All right. So I believe the thing, I guess, Attorney Wagner is to motion to uphold item 5 of the notice of violation. And I think there's other words I should be saying here.
I think I have clear enough direction with the motion to uphold notice of violation 5 for the reasons and findings that the majority of the board has articulated.
Okay, thank you. So all those, I guess I need a motion. I got a motion for that. Anyone?
Right, motion to uphold number 5.
Okay, and a second.
Second.
Okay, any further discussion before we vote? So all those in favor of upholding, David Murch, yes.
Greg Dean, no.
Tom Hennessy, yes.
Fred Miller, yes.
Be Lockwood, yes.
Okay. What's next, Attorney Wagner?
So I believe that's all the issues that I had for this appeal. Unless anybody else on the board sees an issue that we didn't address.
I'm good. Anybody else, board, are you feeling okay?
Yep.
Okay.
So then, at this point, what about again, I think we're gonna, so your ordinance has a requirement that after you make a final decision on the appeal, I believe the written decision has to be done in 7 days, I believe. No, 4 sign.
Attorney Wagner, if I can help, you're absolutely right. It's under section 16G sub 6. Oh, that's actually to the Board of DEP, but my understanding of the statute itself actually requires it within 7 days.
That must be what I'm thinking of. Thank you. Attorney Richard. So what I suggest is we can do the same practice as last time, as I think we've reached a tentative decision here to deny the appeal for the based on the votes of the 4 issues discussed. So I don't need a vote on that at this time. What I'll do is just ask the board to give me the direction to draft up a written decision for next meeting so that you all can review that, confirm it reflects your decision, and at that time make a final decision to deny the appeal.
So directed, please. I'll add a please.
Yeah, and just
David, is there a reason we have to wait a month for this to happen?
Specifically, No, I think it's
No.
a time issue, turnaround time issue.
So if you're comfortable with me writing up the decision based on what we discussed, and I can then have that available for you at the town office, you can then sign that. If you're comfortable with that process, you would make a final decision tonight. So you would take a vote to make a final decision.
I would be in favor of that.
Other board members, how do you feel about that?
It was proposed that we draft it and then review it the next meeting and make it a final decision at the next meeting.
That was my proposal.
is there-
That's based on what we did before. And then
Is there like a due process requirement to give that delay or any statutory?
I might defer to the parties to give their positions on that.
If I might, Mr. Chairman and members of the board, a couple of things on that. I think that your past practice is what is most often done in circumstances like this. When you have a complicated situation, it gives the attorney, and I'm often sitting where Attorney Wagner is as a town attorney for many towns, that it gives them some time to actually craft, well thought out findings that this case deserves. But also from just a procedural standpoint, it's always been my understanding that if there are draft findings, that they need to be taken up and voted on at a public meeting. That I don't think it's possible to just authorize the chair to sign them without voting upon those draft findings, without having seen them and deliberated on them in a public meeting. So I would suggest that it is that the practice that you followed last time around would be the appropriate one to engage in. Those are my 2 cents. Thank you so much.
Yeah, I understand. I think, Tom, where you're coming from. I mean, part of it for me though is given the complexity of all this. It's just, for me, wiser to go just a little bit slower and ensure everything's properly laid out in terms of the decision.
I'm okay. I wanted to ask
Yeah.
the question because
Yeah.
we've seen what 4 months of tabling did for us.
I mean, Dave, can I say something?
Of course. Yep, go ahead, Fred.
I would feel much more comfortable if we put it out for the month and have it at the next meeting. That way we can actually see it, in writing and then vote on it.
Yep. So I guess, Tom, we will, it's out there to discuss this for our next meeting. So.
I'm okay with it. I wanted to ask the
Okay.
question, being
No,
that
I'm glad you
this
did.
process is dragging out forever, it seems like. So.
Yeah, understood. So. All right, so I guess we'll move forward to, yes, Attorney Ratchin.
I'm so sorry. This is just a clarification. I think we all know this, but just to have it on the record, that the final vote has not been taken and therefore the appeal period is not ticking. I just wanted to make sure that everyone agrees on that.
That's correct.
Thank you so much.
Okay, so we'll move forward, Attorney Wagner, with what we had originally discussed.
Okay, so we'll go forward with that. So that's everything that we have for that appeal. So speaking for myself, I'd love a brief recess before jumping into the next one, but maybe just let's get all on the same page about what that next one is.
Yeah, I'm in agreement with you on the brief break, and I would be my understanding that we would be looking at administrative appeal, re-notice of violation issued on 12/28/2021, applicant Durant Excavating, location 18 Fernwood Road, administrative appeal from notice of violation. Does that match everybody else's expectations? Okay, and to clarify before we jump into a brief break, our bylaws have been updated. So as of 10 p.m., we will not take on any new topics on our agenda. And we also have a hard and fast deadline of midnight for terminating any further discussions that are open during our meeting. So how about a 5-minute break? Does that seem appropriate? Meet back here. I'm showing we just turned at 9 p.m. So meet back at 9:05. Does that sound appropriate to everyone?
Yes.
Good.
Hey, for me.
We'll do that. Okay, how are we doing here?
I think we're still broadcast muted. Yeah,
You're back.
we're back. Okay.
Tom.
It's Ricky. Ricky boy.
I'm here, David. I'm just going to mute my video until we get started.
Gotcha, Greg. Just waiting on Tom. Hey, Tom.
Hi.
All right, Greg. Looks like we're good. I don't see Alex, but see Attorney Wyckoff. So we'll go ahead in interest of time and move forward. So if I remember right, Attorney Wagner, I need to reestablish a quorum. Is that correct? Yeah.
Yes.
All right. So introducing ourselves, David Murch, board members.
Greg Dean.
I'm going to say,
Fred Miller.
Hey, Lockwood.
That establishes a quorum for our zoning board of appeals. If I remember correctly, the next thing is to determine the timeliness of, yeah, I'm seeing a head shake, head nod. So notice of violation for, this was issued on 12/28/2081. Documentation that we received. The appeal itself was dated February 27th, and the town shows it as received on March 3rd. So this is definitely after the 30-day deadline, but if I remember correctly, we have documentation from Attorney Braun with regards to this. Attorney Braun, did you want to speak to this? I believe you had some, only specifically to the filing timelines here.
I did. I also wanted to be certain here. It may just be me with the dates and the documents. There's an awful lot of them going around. But the date of this notice of violation in question isn't in fact 12/28, but it's rather 12/21/21. Is that not the case?
That's what I have to say.
Right.
Okay.
And I think the confusion is that the next one in this line was dated January 28th of 2022. And so I think it's just, there's a little bit of misidentification there that we might just want to confirm and clear up.
Read. So
The town agrees with Council for Durant Excavating that the notice of violation issued to Durant Excavating relating to 18 Fernwood is dated December 2021.
Okay, so I appreciate that.
The next thing I'd like to do, just as far as set the record here, is I know you may not want to take it up, but I would like to make a motion or request to table these matters to a time in the future. Repeatedly, this process is meant to rectify and cure any alleged violations that have taken place on the property. All parties involved, including the town, I would hope, have some limit to their resources. This process is best played out and best addressed when done in a manner meant to find compromise and agreement. And the parties and the appellant in this instance here has certainly acted towards that end and goal. And I would argue that regardless of how much we get through tonight, based on the agenda, as you can see, it's still not going to clear up and conclude the outstanding controversies between the parties. And for that reason, we're essentially not accomplishing what might otherwise be the end goal of these hearings, and that is to come to some sort of finality. And so with that in mind, and again, the idea of, we'll call it economic conservation and best use of resources, I think a continuance of these hearings, an opportunity for parties to finish those attempts to reach agreement is the best practice and policy here moving forward. I mean, candidly, I don't know who benefits from forcing this through.
So Tom, I'm guessing you probably want to speak to this one.
Oh, yeah.
Well, I'm sorry, Mr. Chair, if I can, just before you turn it over to the board, I think you should allow the other party here to have an opportunity to weigh in if Attorney Wyckoff wants to.
Yes, I'll be brief. So the town opposes the motion to continue. At the last meeting, at your last meeting, the members made it clear that they were not interested in continuing the appeals any further. The town heard that. The town prepared for that reality as we understood it as expressed in the last meeting, and prepared for this hearing to be held today. Last week I let the parties know that the town's position is that this appeal should proceed forward today. There have been efforts towards resolving the matter. We're not there yet. The parties can continue down that path, but for now, I think the town wants to complete the administrative appeal process so that the town can be situated to initiate a Rule 80K action if that becomes necessary. The town has spent time, money, and resources to prepare for the hearing today, and we're prepared to go forward. And for those reasons, the town opposes the motion to continue.
I know, Tom, you want to have something to say.
Mr.
My
Chairman,
understanding-
I didn't know if you wanted other council to weigh in as well.
I think you should, Mr. Chair, just because if I understood Attorney Braun's motion, it was to table all matters. Is that right?
It is related to the, yes.
Then I do think you should let Attorney Rachel wait.
Yep.
So I didn't mean to jump ahead in the queue. I'm happy to wait. Mr. Chairman,
You're fine. I appreciated the clarification. I thought I was only specific to these for Durant Excavating. So yes, please, Attorney Rowson.
Thank you. So I have absolutely no objection to that. I hear somebody in the background. I'm not sure if that's intended or not.
Yeah, no, I apologize. My daughters came in and they're in the background. Sorry.
I have compassion. Usually it's my dog. So we have no objections to that continuation, and particularly if it affects all further agenda items this evening. We do absolutely concur that this is an unfortunate and colossal waste of resources that the town itself is paying 2 attorneys to be here when we are trying very, very hard and I'm hoping productively to come to a resolution of this matter. That said, of course, we're prepared to continue. We're prepared to present if we reach the next appeal, but I 100% agree that everybody's resources are being wasted, given the fact that we're making very diligent attempts to resolve this matter.
So, Mr. Chair, I just want to disclose to the whole board the conversations I've had with numerous parties about this issue. There was some anticipation that there might be a request to continue, and I had those conversations with Attorney Whitehoff and Attorney Rachin, and then sent an email to all attorneys to that effect. And basically, my advice has always been the same. This is, I see it, that this is a discretionary decision for the board to make. I am of the opinion that these sort of timeline requirements to pick up the appeal in a given time is generally a rule that is, I believe the intent is to protect primarily the appellant. But it's absolutely permissible for the board to consider all of the factors that have been laid out by both the town and the other attorneys. And I don't think there's a real clear standard for you to go on other than fairness and what's reasonable to all the parties and the board.
Tom, before I give it to you, I want to hear from Alex. Alex, what is your desire?
I believe Eric already chimed in for me, so I would just rely on his guidance here.
Very good. Okay, Tom, it's all yours.
Okay. When I volunteered for this zoning board, I was under the understanding that we work for free for the town of Raymond taxpayers. And the answer is to try and resolve the violations and validate the code enforcement officer's opinions on those violations. We've gone through 2 of these, believe it or not, in I don't know how many hours we've spent, and validated essentially all but 1 that I can remember. Well, the abundance of evidence from the CEO, the DEP, the Portland Water District, all back all these violations up. And we owe it to our town people that are paying the lawyers fees until reimbursed by the offending parties someday, I hope, to move this ahead. I've heard no progress reports from anyone on what they accomplished in the 4 months of tabling. So I fully support moving ahead, but not being here endless hours.
I'm happy to provide a progress report from the applicant's perspective if you think that's relevant and would be helpful in your decision.
I would prefer to hear it from Attorney Wyckoff, but you're welcome to say your opinion too.
Well, let's hold on a minute here. I think the question is, do we choose to continue to table, if I'm understanding this? And I don't know if this needs to go to a vote or just a mutual understanding. I don't have a desire to continue to table this. I'm in agreement with Tom. We are a volunteer board, and our time is for the Raymond taxpayers, and I prefer to move forward on their behalf to get these these taken care of. So I'm not interested in tabling. I don't know if Tom is, but Greg or Fred, Pete, be just good to hear.
Yeah, I have a couple comments on it. I mean, I don't think we're wasting resources. I think we're addressing numerous and serious violations. I think that that said, we have tabled it for a while, and I'm kind of surprised that I actually would like to hear sincerely what the benefit of tabling is at this point. If we were to table it, it's not obvious to me that there's a material benefit to anybody in tabling it. So if you have if you're willing to entertain it, David, I would like to hear from Attorney Braun about what is it you anticipate accomplishing that hasn't been accomplished in the last half a year or so.
Yeah, Greg, I'm good to entertain it, but Attorney Braun, I'm just going to give you 1 minute.
Sure, certainly. So in the 1 minute, so to speak here, and I'm going to just note to both Attorney Ratchin and Attorney Wyckoff and Wagner for the same. If I seem to say something related to mediation that you think should not be included or stated here, please chime in and cut me off on it. But what I would say is that the applicants in this case have taken significant steps since the notice of violations were issued beginning back in 2021. Work was ceased immediately, and what occurred immediately thereafter was the immediate employment of professionals related to the drafting, development, and agreement on a restoration plan, right? A way to remediate what alleged violations have taken place. Since that time, we've gone through numerous drafts and versions of what might be considered a remediation plan and a method by which to resolve this. And most recently, the parties have employed a new and additional individual who has weighed in and provided the town with further feedback and suggestions as far as what should be accomplished here. From my perspective, and I stand to be corrected, but from my perspective and from my client's perspective, we are choosing in that remediation plan to acquiesce substantially to the town and what their requirements are. And all we're really doing at this point is awaiting a final opportunity to have a meeting of the minds so that we can agree finally on what actual steps should be taken. When I tell you that Rob Durant and the owner, the property owner, are hot to trot and ready to go to make changes and improvements to the land to change and correct what alleged violations have taken place, I mean, that couldn't be more true of a statement. We can't do anything until there is some agreement with the town. And what we would like to do, given how close we are and how engaged in the process we believe we've been in creating and developing and coming to this final agreement, is we'd like to use our resources and time towards finding that compromise, towards having a site visit with all members involved here so that we can clearly determine and illustrate at the property what is to take place. And so again, when we're at a position like this, where 4 different attorneys, 2 for the town, are being paid for these hearings, and I recognize if the hearings were necessary, right? If there was no engagement in the process towards finding a mediated resolution, then you absolutely should be having these hearings. But in the instance where the parties are actively engaged in working towards finding that resolution between themselves, that's when these lengthy 6-7 hour long hearings involving all of these individuals and resources become unnecessary and become a waste. And so I would present to the panel. Thank you.
Yeah. It took 1, went to 3, but that's okay. So Greg, did you get your answer?
Yeah.
Give a mouse a cookie.
Yeah, I think, having heard that, honestly, I come to the opposite conclusion based off of what you just said. I mean, the fact that you've spent numerous attempts, the word numerous was used multiple times with multiple peoples over numerous attempts to try to come to a conclusion, to me, doesn't bode well to that success of that process. So to me, I would be, I think we should move forward, and I agree there should be a meeting of the minds, and I think the board can help kind of shepherd that meeting.
Fred or Pete, anything final before we move on with this?
Yeah,
So-
no, Dave, I would just say, as the new member, I've spent all day looking at this and reviewing this, and I would have to be in agreement that it's time to move this forward.
Okay. So Attorney Wagner, it's a consensus of the board to move forward.
Because we have there was a motion by a party, I'd suggest that the board make a motion to deny or approve, or deny or grant the motion, have a second and take a vote on that.
Who made the motion? Are we talking the Attorney Braun? Is that?
Yeah, so I guess you're making a motion on a motion. It's a motion to either grant or deny, pick your.
All right.
Yeah, I'll move to deny the motion to table by Attorney Braun.
I'll second it.
All right. Any further discussion? All those in favor of denying the motion? David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Lee Lockwood, yes.
Fred,
Fred's on mute.
I got to hear you, Fred. It's a roll call vote. I got to hear it, Fred. You're on mute, I think.
I'm sorry, Fred, yes.
Okay, thank you. Okay. So moving forward then with this, we have an appeal for notice of violation issue 12/21/2021. We have
I think you left off still on the issue with timeliness, the motion.
timeliness, yeah, exactly. So we have a letter dated February 24th, and then we have it stamped as being received from the town on March 3rd. It's my understanding we have a 30-day timeline. And I believe Attorney Braun, you had, I'm going to give you, please, a little bit of time to just, you had some comments with regards to the timeliness of this. It's clearly over the 30 days. But I know you sent us a letter with regards to explanation of that. If you wanted to take a moment to go through that, or we can just evaluate this specifically from the dates on the letter.
Sure. Well, I guess you're giving me, as you say, a few moments there, but I guess I'd ask clarification from the board and from your attorney as to what you believe your review is here. I mean, is good cause not unequivocally a consideration?
I'm just trying to determine why why it was file faked. I believe you had provided the board some information. I'm just giving you an opportunity to discuss that.
So I can just answer that. Good cause is a consideration. So what Attorney Braun is referring to was under your
Okay.
So it's sort of a two-part. You know, if you've made a factual determination that it was past 30 days, it is untimely. And I think you've made that determination. So now you can enter into a discussion about whether you think there is good cause to waive that 30-day requirement. Your ordinance, I do not believe, defines good cause, but the law court has, and it's defined it as a flagrant miscarriage of justice based on the totality of the circumstances. So a lot of words to say. Look at the facts, hear Attorney Braun's arguments, and in your mind, would it be a flagrant miscarriage of justice to not allow this appeal to go forward? You know, keep in mind principles of reasonableness and fairness.
Thank you.
And thank you, Attorney Wagner. And that's what I would just restate here and make certain that all members of the board understand is that the 30 days is not hard and fast, right? There is a clear exception to that requirement and rule as it relates to good cause. And in situations where reasonable circumstances would require or would seem to suggest that the 30-day time frame is not necessary or appropriate, and those certain circumstances are usually where there would be a flagrant miscarriage of justice, right? Something that clearly should not take effect or happen as a consequence, right? And so this is a two-pronged test or a two-pronged argument, as it were. And before we get into it, I just want to clarify too, because we discussed it on the agenda, it appears that we were only going to take up the Fernwood matters. I would note that while we're talking about Durant collectively here, one of these does relate to the other ancillary property. And these applications were filed at two different times. The tardiness as it relates to the standard 30-day time frame is different in both of these cases, one by a mere days, the other by a couple of months. And so I would like to know whether or not we're making arguments and discussing it as it relates to both, or if this is just as it relates to the Fernwood, as it seems as though the agenda meant to follow.
Yeah, Fernwood only.
All right.
Would.
So as it relates to Fernwood, then, 2 points then there, right? The first is reasonable circumstances, and the second is this flagrant miscarriage of justice. So the Fernwood application was submitted in the end of February, early March, essentially concurrent with the one for the ancillary property. I will tell you, and please recall that when this was first commenced, when these notice of violations were received by Rob Durant on behalf of Durant Excavating LLC, he was self-represented. He did not have the benefit of counsel. And you may recall that he has never in his history had a single notice of violation issued against him or any of his companies. So these were exclusively new processes and new problems that he was facing. I would argue that the fact that he was pro se should be given some weight as it relates to the actions he took. What other actions did he take as it relates to this specific appeal? Is he immediately sought out and began discussions and moving forward with the town as it related to addressing these notice of violations? He didn't ignore them. He didn't act like they didn't exist. And in fact, he provided some additional follow-up information, which based on that additional information resulted in what are quite candidly cookie cutter notice of violations issued in other entities' names that followed, right? And so he clearly engaged and began in this process. And it was his understanding and belief that new notice of violations naming other parties or entities would follow after that, right? And above and beyond, or in addition to, what we find is that there was some modest calamity of errors. And while we're taking up just the Fernwood one for now, some of this is going to be relevant and specific to the other also. And that's that at the end of February, when some of these deadlines were coming due, and when Rob Durant was intending to file these appeals on behalf of Durant Excavating LLC, he made an appointment with the town and with Alex to meet and discuss them and to conclude the filings. Though that, in fact, was meant to be a meeting on Friday, February 25th. At that time, and as it happens, because we live in Maine, we had a massive snowstorm, and the town office was actually closed on that day, and he couldn't come in and meet as had been intended. And because it's Maine, and unlike other places, we have winter breaks, and I think this actually may have been President's Day, the office was closed on Monday, the 28th. Alex may be able to tell me, in fact, whether or not it's just simply standard practice for that to take place. But what we found here was that due to a snowstorm, the office was closed on February 25th. And then due to the town itself being closed, he couldn't meet with anyone on Monday, the 28th. He did finally meet with Alex related to these in an attempt to make his submissions on that Tuesday, and then he came in again on Wednesday. And what took place on those days is that, and no fault of anyone's here, it's just the way these things happen sometimes, but the primary individual he needed to deal with in the office, who was Sandy, was limited and working limited hours because she'd had hip surgery, right? And my understanding is that the town was relying on Sandy both to provide copies of the relevant maps that he needed to submit as exhibits as part of his application, and was relying on her assistance, or the town was relying on her assistance to establish what the filing fees were going to be as it related to the appeal. And they couldn't do that until she was able to return to the office and answer those questions. As soon as that took place, as soon as all of the information materials were provided, he submitted the application to the town. And so I would argue that there's nothing wrong with this per se, right? He engaged in the process. He provided information to the town. At no point did he simply ignore these notice of violations or act like they didn't exist. Rather, he engaged with the town and worked towards some resolution of them. And as soon as the town and the town resources were able to accommodate it, he did submit the application. And so not just the reasonable circumstances, but we talked to the flagrant miscarriage of justice, right? What would take place here that would be obviously unjust? Well, as you're aware, the sole argument, or at least the initial and keystone argument for this, is that Durant Excavating LLC was never the entity that was contracted to provide these services on site, right? Rather, it was Big Lake Marine LLC. As the appeals are concerned, and for that I would point out to the invoice, it's clear that, can you hear me all right? It's clear that the wrong entity has been named here, right? And so the flagrant miscarriage of justice is finding that the wrong person did something as it relates to these, or the wrong entity did something as it relates to these notice of violations. And it's not just that we have some John Doe or some unknown malfeasor that otherwise committed these. Rather, the person who is before you now has provided you with the appropriate individual to which should answer these questions. And so I would argue that the time frame and the circumstances surrounding the time frame for filing the appeal are met with and dealt with reasonable circumstances, and certainly finding or entering a default decision against an entity that was not responsible for any of the actions that took place here would be a flagrant miscarriage of justice. And for that reason, we would argue that the 30-day period should be waived as is allowed by your ordinances, and that the appeal should be allowed to be heard and proceed.
You. I guess I appreciate the information as it relates specifically to 18 Fernwood. You know, that notice of violation was dated 12/21/2021. I mean, it specifically states right at the very bottom of that notice of violation.
Right. Can I just stop you for 1 second?
Yeah, of course. Yeah.
Want to weigh in on that?
Oh, sure. I apologize.
I saw him turn off his mute and.
Yep, my apologies. Yep, go
Yes,
ahead.
I would like to weigh in. Thank you very much. I'll try to be brief. So here, the notice of violation was issued on December 21, 2021. Now, that was just before Christmas, and the week after Christmas, Mr. Durant came in to talk to Alex, and Alex said to him, you know what, you should get an attorney. And so him being pro se, I don't think that changes his need to comply with what the rules are. And in any event, Alex cautioned him, you know what, you should get an attorney here. And apparently he didn't. So the notice of violation was issued on December 21. The deadline for appeal was January 20, 2022, and no effort was made to submit an appeal. Now, we heard about the quote unquote calamity of errors. Those all were occurring in late February. I think I would submit those have nothing to do with the appeal relating to 18 Fernwood. And I'm not going to address those any further now. I have plenty to say about that with regards to the other appeal for the other property, and we'll be prepared to do that. But that calamity of errors in late February has nothing at all to do with the submission of the appeal relating to 18 Fernwood. The fact is, the appeal isn't timely and should be dismissed.
Thank you, Attorney. Wyckoff. Yeah, as I read the notice of violation that was issued, it clearly states at the end, you must file this appeal within 30 days of the date of this notice. If you fail to appeal the decision within that time period, you'll lose your right to challenge the decision included in this letter. And then it continues, please feel free to contact me if you wish to discuss this matter or have any questions. I can contact by phone at or by email at, and these are Alex's contact information. So I'm looking at this and yeah, 30 days out is January 20th. If I factor in an extra 2 weeks because of the holiday season, that puts us out to February 3rd, which is still, roughly 30 days later. March 3rd is when this was received. So I find this to be extremely far out in terms of the filing. But I would like my other board members to just talk about this, please. What your thoughts are in terms of the timing.
Yeah, I'll chime in. I heard a lot of, not a lot of it seemed like might be more legal stuff that's beyond my understanding, and so I'm trying to parse the what's the simple explanation for the tardiness. Sounds like there was a snowstorm and the town office was closed, and perhaps like a clerical mistake on what the actual title of the recipient was. It's not like they didn't get the NOV. I can't imagine that that's meaningful enough for the degree of tardiness. So I'm having a hard time seeing, like in plain, like if I were going to come in and say it in plain English, like, why is it late? I don't hear that in a simple, candid explanation, frankly.
Yeah, and Greg, for clarification, there's 2 notices of violation. One was for the 18 Fernwood, which was that's the December 21st. And then there's also one for 28 Whitetail Lane, which is January 28th. So those circumstances with C&D and all the other things are more related to that,
I see.
the 28 Whitetail Lane.
So it's not even relevant.
And specific to the 18 Fernwood, they both were filed at the same time. So I guess there's relevance in that perspective, but yeah.
I got you. Okay. Well, even more, I'm having a hard time understanding how it would be fair to just waive such a, degree of tardiness on the appeal.
Tom, Fred.
I guess my couple comments. One was this stop work actually dated back to October of 21. So Mr. Durant was fully aware of his issues for months before he actually got the notice of violation. And I believe, I'm clear on this, and somebody can tell me otherwise, that Mr. Durant is the owner of both Big Lake Construction and Durant Excavating. So there shouldn't be any big confusion over who caused the violations, because they were both owned by the same company, doing the same work at the same 2 sites involved in this violation issue. So, and I don't know when Mr. Braun was hired, but maybe that's the reason that the thing was filed late.
There is like a retainer document somewhere, right?
Yeah, I think so.
Oh, there's just an authorization.
So I fully agree with you, David. This is well over the 30 days, and I'm not sure we heard any valid reasoning behind it, but I'll let the 2 town attorneys chime in if they have an opinion.
I would be interested in, excuse me, Dave, if I can speak, what
Yeah, good.
Wagner has to say on this. Any input?
Or do you want me to weigh in, Chairman Marks?
Let me just see.
Let me preface this with, I'm not actually going to answer the direct question.
I think that's wise.
And I've explained to you
Yeah.
the standard and that you should be guided by reasonableness and fairness. And the ultimate standard is, would there be a flagrant miscarriage of justice without finding good cause?
Thank you, Attorney Wagner. Pete, did you have, or Fred, if you got any follow-up thoughts, and or Pete, anything?
Yeah, no, I appreciate what Attorney Wyckoff had to say, and that fell in line with what my thoughts were too. So I'm good with that.
Fred?
I agree with you guys. I mean, it's definitely way over the 30 days.
Okay. So, Attorney Ron, if it's brief.
It will be, but I think as Attorney Wagner just pointed out, the end or the final decision or consideration should be whether or not a flagrant miscarriage of justice is taking place. And as I think I heard Mr. Hennessy state, this, the guy who owns both companies got it, that should be good enough. And frustratingly, I think that might be the town's argument too. When in reality, the fact is that these separate individuals, these separate unique legal entities exist for a purpose, and being clear to identify which one it is and not citing or finding fault against the wrong entity matters. And it matters not just for, generally here semantics, but I would point out that in the code enforcement manual for the town, I think you find it on page 19 of it, there's an entire section devoted to making sure you get the right name, right? And doing what's necessary to establish who it is or which entity it is that's involved here, right? And I think clearly that was an issue here. And that's why we found that certainly in the case of Mr. Durant, we've ended up with 3 separate versions of notice of violations. One to Durant Excavating, one then to Big Lake Marine, and then one to Rob Durant personally, right? And why did we end up with all of those? Because the town wanted to make sure that they cited and give a notice of violation to the right party. And our argument, right, clearly is that Durant Excavating LLC is the wrong party. And to then refuse our request to hear our appeal, right, solely for the 30-day basis when a flagrant miscarriage of justice would take place is wrong.
May I respond?
Yeah, give me 1 second here. I'm trying to look at something here. And I want to give you my attention with this. So please, Jeff, go ahead, Attorney Wyckoff.
So Attorney Braun just stated that it's clear that the wrong entity was named in the notice of violation of Durant Excavating. That is not true. I mean, the record will show, and Alex testified to this, that emails were sent by an email address for Durant Excavating to both the Department of Environmental Protection and to Alex. And the equipment that was used here to do this work was marked Durant Excavating. So it is far from clear that the wrong entity was named.
Then what that suggests to me, if I may jump in, Chair, and I apologize, is that in fact we do need to establish or get into the basis of the appeal itself, which is whether or not the correct name was correct entity was named, right? Like that then does become the basis of the appeal. Then does become a question that needs to be answered by the board in determining whether or not the 30-day time frame should be waived.
So I'm seeing a notice of violation specifically issued to Durant Excavating LLC. Are you saying, Attorney Braun, that is incorrect?
That's correct.
And Attorney Wyckoff, you're saying that it is correct.
I'm saying that is correct, and I'm also saying there's no miscarriage of justice when the person who receives that notice of violation sits on it, doesn't do anything to appeal it, and just, blows off the deadline. There's no miscarriage of justice there.
Well, and I disagree with those last statements. In fact, I guess I might ask Alex to weigh in as it relates to what sort of conversations or efforts and discussions he had.
Yeah. So Attorney Braun, you don't have, that has to come through me, and I'm not gonna. I think the matter is we have something here to Durant Excavating, notice of violation. We have something filed on behalf of that. On behalf of that applicant. And it was filed approximately 3 months, well, January, 2 months after a 30-day deadline. So fellow board members, unless I'm missing something here, and unless you want to discuss this further, I am of the mindset that we're not to move forward with this one as it falls outside of the 30-day time frame. And I think I don't believe there's a miscarriage of justice here as you know, having heard the two sides. But I would appreciate just some feedback from the four of you, and then we can make a decision on this.
I think, is it possible to get some guidance on the threshold for what a miscarriage of justice is? Is it, I mean, it seems instinctively, we deal with different thresholds and all sorts of things, and sometimes there's strong like guidance on how to perceive that, and that might be helpful here. If not, then you know, my instinct is that it's a high bar, higher than, you know, I just had a different name on it than I'm used to, or you know, I was busy and didn't get to it. Doesn't quite seem like that's it, but I'd love to hear more about what the actual threshold is if you're open to explaining it.
Who are you asking that question?
Attorney Wagner, sorry. I'm looking at him, but like I'm supposed to be.
Challenges of Zoom. Huh?
Yeah.
So I've given you what I know off the top of my head and what I'm prepared to discuss. And, you know, I'd represent that it's a question that's based on the totality of the facts. So I don't think I'm not aware of any precedent saying it's a super high bar. It's really a matter of discretion for the board. That being said, you are of course welcome if you want a legal and a written opinion that lays out. So part of your question was, you know, guidance. So how you would get guidance on this is good cause is a doctrine that's, well, it appears in your ordinance. It's been developed off of case law. So I could offer you a written opinion on what the case law says that could be relevant to this case. Again, I'm not going to, my preference would not be to answer the question for you, but I can lay out how the court has described the good cause standard and give you some cases about that. You're certainly within your, that's your prerogative if you want to pause on this decision and consider it with the benefit of further legal advice. That's your call.
Yeah. It's and if we obviously if we procedural follow-up question, if I might, assuming we don't hear this right now, the default judgment is basically, you know, the appeal is just denied in totality, and okay, and I don't know, I guess, David, I'm a little long-winded here, but I guess maybe I think it might be prudent, at least for me, to understand exactly the I mean, because there's, I think it'd be worthwhile to hear our Attorney Wagner or read Attorney Wagner's kind of a case summarization, as he said, or the case law related to this before we weigh in, given the gravity of the outcome for the appellant.
I would be in agreement with that, Greg, as more information can always be better. Is there anybody who's against getting some more information on this? Okay. So then I guess we will sort of put this one on hold then.
I guess, yeah, maybe just so I'm clear, maybe if you can just make it a motion to continue this particular appeal to the next meeting and instruct me to prepare I promise you, brief written opinion on good cause.
So moved.
I'll second. Any further discussion by our board? All those in favor? David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Bill Lockwood, yes.
Okay. And given the time of 9:55, we've effectively taken ourselves to the end of the night. I'll need a motion to, these are additional administrative appeals, which we took off the table to put back onto the table until our next August meeting. To have a motion for that.
So moved.
To have a second.
Reluctantly, yes.
Okay. Any further discussion? All those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Bill Lockwood, yes.
Okay, so any administrative appeals that we did not get to tonight are effectively tabled until our next meeting. Anything you would like to add, Attorney Wagner, before we move on to our last few agenda items?
And no, just to clarify, so we've got, this is mostly, I guess, for my own tasking benefits. I will get, as soon as possible, and certainly within 7 days, a final written opinion on the first appeal to Sandy, and she can urge you all to get that signed and distributed.
Actually, yeah, that's the first one, correct?
Yep, that's the first
Okay.
one. And the
Yep.
second one, the NOV on Q teams for 1/4/22 pertaining to 18 Fernwood. We have a tentative decision, and I will draft that decision up and circulate that in advance of our next meeting. So finishing that appeal will be, I believe, would be the first item on the agenda as it pertains to these appeals.
Yep.
Attorney Braun.
Apologies, just since we are now tabling these to the next date, I'd like to just confirm what that next date is. My fear here is that it's going to be Tuesday, August 23rd. Is that correct?
No, it'll be Tuesday, August 30th.
Okay, very good.
Attorney Ratchin and Attorney Wyckoff, you have any questions before we move on? Just want to make sure you have an opportunity.
Actually, I do have a question.
Sure.
Are you tabling further consideration of any appeals today? Is that what you're doing?
Yeah, our deadline for time limits is 10 p.m. to take on anything new. If we were to move on to another administrative appeal, that would be a substantial time.
Okay, I misunderstood that. I guess I read your rules as saying that new business can't be done, but old business can, and all of these appeals are old business on the agenda. Am I wrong in how I understand that?
Greg, do you want to speak to that?
I would defer to Attorney Wagner. No, I think the spirit of the time constraint was to prevent addressing new business items, whether they be new business or old business. Maybe there's some ambiguity in the word new, but I can appreciate the confusion, and maybe that's something we could address. But it would be kind of net new business items, whether they come from the new pool or the old pool, they would still be new to this meeting.
So I don't know, like, as a practical matter, yeah, I appreciate that. This was a practical matter, then I think that means you can, going forward, you're going to be able to do 1 or 2 appeals at a meeting based on how it went today.
I think it's at the board's, David, you can chime in on that, but.
Yeah, I mean, we do our best, so I don't know.
Yeah. I would say that rarely does one item take 2 hours or the bulk of 2 hours. So I would say it's definitely 2, if not 3 or 4. But yeah, and it's also at the discretion of the board. So there's that's that kind of bylaw is borrowed from the planning board as well, verbatim. So it's not sort of novel thinking on our part.
I would suggest if Attorney Wyckoff or Wagner have a better way to do it or a way to expedite, I'm all in favor.
Yeah, and in the past, we've had special meetings to kind of clean up, and we could do that too. It's just a little bit hard to orchestrate, but that's the.
Attorney Braun.
Just for the record, I'd like to note that at the first hearing we had, that's exactly what I suggested, was that we set up a special hearing, and that twice now we haven't gotten through it, and it's appeared that a tabling both was necessary or appropriate given the circumstances. And, you know, counting heads here, I think most of us prefer to conclude our work at 10 o'clock.
Yep.
So to answer your question, Member Dean, yeah, we can be creative here. I mean, we can have a candid discussion. We can drop the formality here. You know, if we want to agree to just to save all the attorneys, myself included, from having to perhaps prep for all of the appeals, we can identify just the 1 or 2 that the board will consider, regardless of the time. We could set up a special hearing. I have concerns that we'd all be able to coordinate schedules to make that happen, to be honest. Whereas I've already got this date, you know, booked off, as much as it does mean late nights. But I welcome the sort of free discussion between the attorneys, as I'm getting the sense the board is looking to us to figure something out.
Yeah, for my part, I'm happy to do whatever is efficient. I agree that maybe a special hearing is in order. As far as timing goes, I will tell you that I have scheduled, you know, vacations and whatever around the board's specified calendar. So if we are to schedule one before, or the thought is to schedule one before the 30th, I would not be able to do that. But I'm absolutely open to having a special hearing to consolidate, you know, do it. But again, I appreciate people may be working during the day, and that might not be feasible. But whatever is efficient and, you know, works for everyone involved, I'm more than happy to do it, just as long as, you know, I did book off time understanding what the calendar was.
May I make a suggestion? And my suggestion is that the attorneys have a call to see if we can't figure out some way, if there's a way to expedite this so that we can become more efficient.
I think that's a good idea.
I don't have any answer, but
A step forward, right?
I mean, I think
Good luck to you then.
I mean, I think the issue is that in the event that there is an appeal, the parties require to have certain things in the record in order for that, you know, for that appeal. That's the real issue. That's why there's time that's being taken here.
Yeah, I agree, and I think I've just also got to weigh in. You know, part of the, you know, I perhaps sometimes could be a bit overly formal about how I'm conducting this with findings, and part of that is recognizing we have a complicated record, and I want to have a clear record on appeal or on 80K if that's where this goes. But another part is whenever we're doing it by Zoom, it is a little bit slower because we have to do those roll call votes, and that, you know, that does slow it down. So perhaps also, again, I think we can take this offline and figure it out, but you know, maybe in person, or yeah, it's probably not worth it either. But anyhow, just wanted to say that.
For what it's worth, I like the idea of kind of make like up ahead of, you know, in advance identifying, you know, specifically what we think we can get in. So at least, you know, we don't have attorneys sitting around in the off chance that we end up, you know, getting to it. It just may be, you know, unfortunately, a more efficient use of scheduling. But that increases the timeline. But I think we're all certainly open to making it more efficient. So that's the good news.
Well, I think we've got, we speaking collectively from the attorneys, some direction from the board, and I think we can figure it out.
Okay, very good. I appreciate all of your time tonight. Alex, we're going to skip you because unless you've got something super exciting to tell us.
No, you can skip me. Please skip me.
All right, you're skipped. So last item on our agenda is for adjournments. Can I get a motion for adjournment?
So moved.
I will second. All those in favor, David Murch, yes.
Greg Dean, yes.
I'm gonna say yes.
Fred Miller, yes.
Lee Lockwood, yes.
Very good. Thank you all. Thank you, Sandy.
Thanks, everyone.
Thank you.
For the time.
Good night, everyone.
Night.
Good night.